professor with tenure. It's important to include that qualification, since this is an institution where we don't grant tenure at associate. But associate professor with tenure at University of Missouri Law School. And Tom, the floor is yours.
Excellent. Well, I'm excited. I don't think I've ever had so many people read anything I've ever written. So I'll be very excited to get your comments on this paper. You know, the trick in writing these sorts of papers is to identify a common thread that's running through a series of cases that the courts has decided. And I had read these cases. I teach antitrust law. I taught them in my class. When Jonathan asked me back in the spring, I think, if I would be willing to write this paper, I said, oh, okay, sure. I can come up with something to say. I got kind of busy on my other summer research and kept thinking, well, I've got to write that Roberts Court paper, so I thought about it, but didn't really put any pen to paper until the 1st of August. And I thought, okay, well, here is a theme that I can fit these cases in. The theme is that the Roberts Court antitrust cases are all about minimizing the sum of decision and error costs. I thought I would probably have to do a little shoehorning to get some of the cases to fit that theme. And as I started to write the thing, I was shocked. And it's a matter of dumb luck or providence or whatever. They did actually fit the theme really, really well. It's really striking. So basically what I do in the paper is set up what I call the decision theoretic model, which is based on the notion that antitrust is an inherently limited enterprise. That's the first part of the paper. The second part of the paper then just marches through the Roberts Court's major antitrust decisions and shows how they sort of cohere with that theme. They follow its prescriptions. And then finally, in the last part, I make some predictions about what I think the court will do in the future if it sticks to this sort of decision theoretic approach to deciding antitrust cases. All right, so let me start by quickly sketching out what I mean by the decision theoretic approach. The model here, which is not my own, it draws quite heavily on work that Judge Easterbrook did, an article he wrote called The Limits of Antitrust in the Texas Law Review in the 80s. It is not, however, an exclusively Chicago School theme. There are members of the Harvard School of Antitrust Analysis, including Justice Breyer, who reason quite explicitly in these same sorts of terms. So I am not inclined to call this a Chicago School position, although many members of the Chicago School have bought into this notion of the limits of antitrust and the decision theoretic model. This is basically what the model does. Antitrust, everybody knows, is the body of law that is designed to maximize competition. Competition is the greatest thing from a consumer standpoint. It's the best regulator designed to ensure that we have low prices, high quality goods, lots of product variety, etc. So the purpose of antitrust is to maximize competition. Now we don't understand competition to consist of just having a whole lot of competitors. In fact, if we broke up many concentrated markets that are subject to economies of scale, we would probably be worse off with more smaller competitors. So the law pretty early took the view that competition, when we talk about it, the antitrust standpoint, means output. A market is more competitive to the extent that it gives us more goods and services and at lower prices, higher quality goods and services and at lower prices, and less competitive when it doesn't do those things. So we have this output-focused understanding of competition. What the antitrust laws do in order to ensure that we have vigorous competition is basically police the two big situations where competition can break down. One is monopoly, when you have a single seller. The other is collusion, when competitors agree not to compete with each other. Now, the way antitrust does that is it's the opposite of securities law. We could not have a series of antitrust cases that are, that we can explain away as matters of statutory interpretation. We have no statutes to interpret, really. What antitrust does is we've got very brief statutory proscriptions that deal with these two paradigmatic breakdowns in the competitive process. So Section 1 of the Sherman Act says contracts, combinations, and conspiracies in restraint of trade are illegal. That deals with collusion. Section 2 says it's illegal to monopolize a market. That deals with the problem of monopoly. Now, the problem here is that these are completely standard-based proscriptions, right? The law doesn't prohibit anything in advance. We decide after the fact whether a practice is okay or not okay. And what the courts have had to do is they've had to read into the statutes these notions of reasonableness. So Section 1 of the Sherman Act says every contract, combination, conspiracy, and restraint of trade is illegal. Well, that cannot possibly mean what it says because every contract restrains trade. And so the court very early on said, this prohibits unreasonable restraints of trade. With respect to monopolization, the court said Section 2 prohibits unreasonably exclusionary conduct. Right, so what we have there then is a standards-based approach to liability. The law is privately enforceable. Anyone injured in his business or property by virtue of anything forbidden in the antitrust laws has a right to sue. Now, the courts have cut back on that substantially by creating all kinds of procedural hurdles, but in the statute there is a private right of action, and there are treble damages because many antitrust violations occur in secret, and we need to sort of give a bounty in order to account for the fact that many violations go undetected. What we end up with then is this standard-based body of law where a court has to decide in every single case whether a novel business practice is or isn't reasonable, and where private plaintiffs have a strong incentive to bring lawsuits because they can get treble damages. This process is extremely costly. The most obvious cost is just the cost of reaching a decision. In every single challenge to a novel business practice, a court's got to decide, or a fact finder has to decide, is the practice reasonable or unreasonable? And remember, we're looking at an output-focused body of law, and so we're going to have economic experts that say this practice leads to more output or leads to less output. It's going to be messy, complicated, difficult question to resolve. So first we've got the cost of just reaching a decision. I call that the decision cost. Secondly, because of the fact that the issues are so nuanced and complicated, mistakes are inevitable, and those mistakes themselves will be costly. If we have a false negative, that is, if the failure to convict a practice that is truly anti-competitive, then market power is created, and with market power we get allocated inefficiency, a social loss. If we have a false conviction of a practice that is actually pro-competitive, then we have that practice condemned throughout the economy, and that leads to a productive inefficiency. We lose the benefit of a pro-competitive business behavior. So if a mistake in either direction is going to be really costly. Okay. Given that we have decisions that are costly to render, just to reach the decision, and inevitable errors that themselves will cause costs, those will be taken together error costs, the goal of the law should be to minimize the sum of decision and error costs. This is the decision theoretic model, and I call the paper the Roberts Court and the Limits of Antitrust, because the decision theoretic model is designed to deal with antitrust's inherent and inexorable limits. All right, so that's the first part of the paper. The second part of the paper just marches through the Supreme Court's decisions and shows how each of them can pretty much fit within this model, can be explained as cohering with this model. The first decision is the Legion decision, or Legion decision. Legion said that minimum resale price maintenance will be subject to the rule of reason. In the past, this practice had been per se automatically illegal. Minimum resale price maintenance is when a manufacturer dictates to his retailers the minimum price that can be charged for a product. This is really a mixed bag practice. I mean, economists have recognized that there are certain circumstances under which RPM can cause anti-competitive harm. And there are also lots of circumstances under which RPM can enhance market output. So this is it's not one of those practices that's always or almost always anti-competitive. The theory and the evidence both suggest, and I argue this, explain why this is so in the paper, I won't do it now, that pro-competitive uses of RPM will be more common than anti-competitive uses. So an error cost analysis, if we're going to try to figure out the liability rule that minimizes the sum of decision and error costs, if you're looking at error costs, we're better off having a rule that puts the burden on the plaintiff to show anti-competitive harm. Now, in doing so, we may raise decision costs over what they would be under a per se rule. A per se rule says the practice is automatically illegal. If you prove that the practice has occurred, you've established liability. That's relatively easy for courts to figure out. The problem is that because the per se rule against RPM was so economically deficient, the court over time created a whole bunch of loopholes, and those loopholes became extremely difficult to administer. So while the Legion case does raise decision costs somewhat, it doesn't raise them all that much. And in addition, it dramatically reduces error costs. So this is a decision that makes sense in terms of minimizing the sum of decision and error costs. I'm not going to go through all of these cases in that great detail. I realize my 15 minutes are about up. The Weyerhaeuser case, in that case, the court held that predatory overbidding claims would be subject to the same test as predatory pricing claims, the Brook Group test. Here, the court pointed out, and I think correctly, that predatory overbidding is rarely tried. It's even more rarely successful. There are lots of good, or at least benign reasons why a business would want to buy up lots of inputs, buy what seems to be more that it needs. If we make it too easy to establish a violation, we're going to chill that sort of pro-competitive behavior. And again, this is a violation that doesn't occur very often, and so it's probably not something we should worry about. Thus, the court adopts what is definitely a pretty pro-defendant rule, but it seems appropriate from a decision theoretic standpoint. The link line case, in that case, the court held that where a vertically integrated monopolist, and what I mean there is a firm that operates in both an input market and an output market and has a monopoly or market power in the input market. If the vertically integrated monopolist has no duty to deal with its rivals in the input market, then it can't be liable for a price squeeze. And a price squeeze would be you've jacked up the price of your input, lowered the price of your output, and driven out your competitors in the output market who have to buy the input from you. The link line case, read it closely, is based on, or not, you don't have to read it closely, if you give it a quick glance, you'll see that it's based on two very well-established, or one well-established Supreme Court decision and one relatively new Supreme Court decision. The Brook Group case that says that price cuts are legal, per se legal, unless they result in below-cost pricing for the discounter's product. And then the Trinco case that says that a monopolist has no general duty to deal with its rivals. Both of those decisions can be explained on decision theory grounds, and link line, which is the product of those two decisions, thus seems explicable on decision theory grounds. I can go into much greater detail about why these cases are correctly decided if anyone's interested, but I want to get through this quickly. The independent ink case, in this case, the court held that in a tying case, tying requires that the defendant have monopoly power in the tying product market, tie in a tied product, and then have some not insubstantial effect on commerce in the tied product market. In order to establish market power in the tying product, it's sufficient, the old view was, to show that the defendant has a patent on the tying product. In the independent ink case, the court said that presumption of market power based on possession of a patent in the tying product market will no longer exist, that it's up to the plaintiff to establish market power in the tying product market. From an error cost standpoint, this is a no-brainer. the vast majority of patents confer no market power whatsoever, and so it's very hard to defend the old presumption. In the paper, I talk about what I think is the more significant thing to take away from Independent Inc., and that is that the court seemed to indicate that price discrimination, just pure price discrimination through metering, would not be taken to be an anti-competitive effect of the antitrust laws. But I'll talk about that in comments later on. The Dogger case, the court held that when parties to a lawfully constituted joint venture set a common price for their product, then that is not a per se illegal instance of price fixing. This is also, I think, a no-brainer. If the law were otherwise, every single post-formation decision that a joint venture makes that involves limiting output in some way, deciding to sell to some customers and not others, deciding not to adopt a particular product feature, anything related to pricing, those would be subject to a per se challenge, and the defendants would have to show that the decision at issue was necessary for them to be able to market their product. Very, very difficult rule. It produced tremendous error costs and lots of decision costs as well, because there would be lots of challenges. So from a decisions theoretic standpoint, the Dogger rule makes perfect sense. In the Credit Suisse case, I won't even really talk about here because Adam did a great job talking about that. Basically, antitrust challenges to certain securities marketing practices are preempted by the securities laws. The most interesting thing to me about this case was Justice Breyer's decision and how explicit he was in embracing a decision theoretic approach in deciding that there's a conflict between the securities laws and the antitrust laws. Now, there was no apparent conflict because the SEC had already condemned the practices or that the plaintiffs were saying violated the antitrust law. So there doesn't seem to be an apparent conflict between antitrust and securities. But Justice Breyer said, actually, to decide whether there's a conflict or not, what we're going to do is we're going to weigh the value of antitrust versus the cost of antitrust. I mean, this is explicitly a decision theoretic approach. He found that mistakes in antitrust litigation were likely, that mistakes would be very costly, and that on the other hand, a rule where antitrust stayed its hand, while it might produce some false negatives, it would allow some anti-competitive practices to be acquitted. The cost of that would not be that great because securities law already covers the practices at issue, and the practices could be condemned under the securities law. So we don't really need antitrust. He's very much focused on the cost of antitrust versus the benefits. The Twombly case, which I know Professor Fitzpatrick is going to talk about tomorrow, and everyone is familiar with, I will only briefly mention. The court, of course, held that allegations of parallel conduct plus bald assertions of a conspiracy were not enough to survive a motion to dismiss in an antitrust case. I know Brian is going to talk about the implications of Twombly and its companion case, or not a companion case, but the Iqbal case more generally tomorrow, so I won't get into that. But from an antitrust standpoint, especially one that focuses on the limits of antitrust, this makes perfect sense. Parallel conduct among competitors is ubiquitous. Every wheat seller in the country charges exactly the same price for wheat. The reason for that is not that they've all agreed on what the price of wheat is going to be. It's because competitive considerations, lead them to the same outcome. If parallel conduct plus just some bald assertion of a conspiracy were enough to get you to discovery, then we'd have all sorts of non-meritorious strike suits filed in order to extract a settlement. And so it makes sense to have, not to allow the allegations at issue in Twombly to state a cause of action. Now, I won't say more about Twombly's implications for civil pleading generally. I'll leave that to Brian. The last case, and this is the one I thought I was going to have a hard time with, is the American Needle decision. Unfortunately, my friend Josh Wright wrote an article that is to be published on Friday, I suppose, where he makes the point that the American Needle decision is actually quite consistent with a focus on minimizing error costs. It's quite consistent with decision theory. In that case, the court confronted the issue of whether the members of the NFL and this organization that they had created, the NFL Properties, were capable of conspiring for purposes of Section 1 of the Sherman Act. The court, in deciding the case, seemed to limit the doctrine of intra-enterprise immunity, that is, agreements between entities that are really part of the same larger economic entity. It seemed to limit that immunity to situations where there's a complete unity of interest between the various parts. And it allowed the case to go forward. This is the standout in this list of cases. It's the only one that the plaintiffs won. It's the only one that a antitrust plaintiff has won in 16 years. How could this possibly be consistent with decision theory? Well, Josh and his co-author make a really good point, that from a decision theoretic perspective, this decision makes quite a bit of sense. The old intra-enterprise immunity doctrine that was set forth by the court in the Copperweld case turned out to be very difficult to implement. Its heart was in the right place. The idea is that, if you've got two parts of the same economic organization who, technically are separate beings, but they're pursuing the same goal, that when they agree, they're not really reducing the centers of economic decision making in the economy anyway. There's not likely to be any consumer harm from that, and we should give this a pass. It's an excellent screen, or in theory, it would have been an excellent screen for getting rid of non-meritorious antitrust actions. In reality, it was so very difficult to implement that we were having very costly disputes at the outset of litigation over whether we had two entities that were capable of conspiring. The screen that Copperweld posited in 1984, Josh and his co-author argue, and I think this is correct, is much less important now, much less necessary than it used to be, for a couple of reasons. The one that they focus on is Twombly. Twombly says that in order to survive a motion to dismiss, you have to allege a plausible conspiracy. Well, if you're, in your complaint, you're saying that two units of what seems like obviously one organization have come together and agreed, the theory of consumer harm is not very plausible. We can probably toss quite a few non-meritorious intra-enterprise conspiracies just under Twombly. In addition, since 1984, the rule of reason has become a lot more structured and a lot more predictable. It used to be that a rule of reason case involved basically throwing all the facts on the table and making a gestalt-like decision as to whether the world was a better place with this practice or a worse place with this practice. Since 1984, the court has substantially tightened up how the rule of reason it should be implemented. It's much more structured now. So if we send to discovery a case that probably shouldn't get there, it's less likely to be a huge mess in a rule of reason adjudication than it used to be. So these two things taken together, Twombly and a tightening of the rule of reason, make the Copperweld screen less important. And since the Copperweld screen was quite expensive to implement, it makes sense to go ahead and get rid of it. It had very, very high decision costs. All right, so having gone through all of the decisions that the antitrust decisions the court rendered, showing how they cohere with this decision theoretic model, I then turn my attention to sort of predicting the future, and I make three specific predictions. I predict that the court on the issue of tying is going to change the rule. Right now we have a quasi per se rule against tying, which says basically if a defendant has market power in a tying product, ties in something else, and affects a not insubstantial amount of commerce in the tied product market, and that's a dollar volume of commerce, which the court said $60,000 will suffice. Then we have an automatic violation of the antitrust laws. Economists have criticized this rule for decades, and the court came very close to getting rid of the quasi per se rule in the Jefferson Parish case. I believe that it will do that it will hold that there's no liability for tying absent substantial foreclosure of marketing opportunities in the tied product market. That would bring tying doctrine into a line with the liability rule on exclusive dealing, which is a very similar vertical restraint of trade. And the court, specifically in the Independent Inc., made some remarks that suggest that the price discrimination effects that tying can sometimes cause are not sufficient to establish liability. So it seems to me, based on reading these cases, that tying is going to get changed here pretty soon. The other two predictions I make deal with discounting practices, and they're very similar. With respect to loyalty rebates, a loyalty rebate is when a seller says, if you meet some purchase target in my product, you buy 90% of your requirements from me, or 100,000 units from me, or whatever. Once you get to that point, I will give you a rebate on all the previous products you purchased from me. I believe the court is going to adopt the rule that says as long as the discounted price of the product being sold is greater than the defendant's cost, the loyalty rebate is per se legal. If it does so, it's going to put itself at odds with a Federal Trade Commission, and I think the Department of Justice now, but the FTC recently went after Intel for this sort of loyalty rebate, and the FTC's position was that these types of rebates can usurp so much business from competitors of the discounter that it can drive them below minimum efficient scale and raise their costs, and that can be anti-competitive. The problem with that sort of a liability rule is that a court has to decide what is minimum efficient scale. Extremely difficult to do. This court that's very focused on the administrability of the antitrust laws and doesn't want to chill pro-competitive behaviors like price cuts is not going to accept that. I think they'll adopt the rule that I just set forth. On bundled discounts, a bundled discount is when you give a discount basically on a package of goods. We currently have a circuit split, so maybe we'll, no, apparently the court likes to weigh in on circuit splits. It's not too much of a circuit split. It's fairly recent between the Third Circuit and the Ninth Circuit. The Third Circuit decided a case, LePage's, which is condemned a bundled discounting scheme even though the discounted prices were above the seller's cost, and even though the plaintiff admitted that it was a less efficient producer than the discounter. But the court decided that, it's possible that there could be anti-competitive exclusion because of this discounting practice. The Ninth Circuit decided a bundle discount case recently and held that there's a safe harbor. If you take the entire amount of the bundle discount, you attribute it to the product that competes with the product the plaintiff sells, and the product is still sold above cost, then the discounting is okay. This court, I believe, at a minimum would adopt that safe harbor. So that's my theory and my predictions, and I'm happy to hear what you have to say.
Josh?
I've got comments and questions. I agree with all the characterizations of the cases, especially the ones that cite me. I don't disagree with those at all. My comment is, so you say this up front, you say that, and I agree, you view the cases in the same way. The error cost decision theoretic approach is about, we weigh these costs and benefits of errors and administrative costs, and the aim of that system of designing liability rules is maximizing the rate of return for consumer welfare. And in your discussion of Legion, you talk about the empirical evidence. And what I'm going to, my comment is going to be for the paper is to push you harder on the empirical evidence, because it is, to the extent that that's the goal of the error cost approach, the punchline is how's it doing for consumers? And you make the case, but it's way stronger than you make it. In RPM, you cite Ippolito and the Overstreet studies, the subsequent literature reviews, the Cooper paper and LaFontaine and Slade, there's not a single respected empirical study that would survive peer review or even close that finds anti-competitive effects. So you have theories that go both ways, and you spell them out really nicely, but the evidence is that RPM is not only doesn't meet the almost or always anti-competitive, it's probably almost or almost always, I think I said that right, always or almost always pro-competitive, and it's not close. Now, there's not 2,000 studies, there's 30-something, but it's 33 to nothing. Like where Adam's record is headed, 3-0 after today. So the empirics, and then sort of in the paper you drop off the emphasis on, so how's the rule doing empirically? Now, I understand why. In Legion, the court talks about the empirical evidence. They bring it up. But for the purposes of your paper, I think it's fair game for you to bring it up. So, for example, is the empirical evidence any different for predatory overbidding, for predatory pricing, for price squeezes? It turns out the answer is no, right? And there's sort of really good literature reviews on the topics. But the evidence for that category of conduct is so overwhelmingly one-sided in terms of the empirics. I think it really strengthens your paper to say, not only is what the court doing consistent with this error cost approach, but the approach is working, right? And that also, I think, has obvious payoffs for the, pro-business versus pro-consumer stuff. It's not just silly to talk about that when you've got business versus business cases. It's also silly to talk about it when there's business versus business cases. But to frame that as somehow informative of the pro-consumer effects is silly for a different reason that I think the empirical evidence eliminates. That's the comment. The questions I'll make shorter. Your predictions are great. I want to ask you sort of for something that's not in the paper, which is, so big area of antitrust that nobody likes to talk about when they do these error cost papers, including me, is merger law, right? So everyone agrees Jefferson Parish is sort of, it's the next one to go if something's got to go, right? It doesn't make any sense. It's next in line, okay? And it's got seniority, right? Merger law, we haven't taken a case in 30 years. Almost got Whole Foods, but didn't get it for reasons you've written about. So what happens with merger law within the error cost framework? And I ask this in particular because merger law is one of these areas where, unlike the other areas of law, we look backwards at evidence. Now we're looking forward, and it's one reason that the justices don't want to touch it. It's harder because you're making predictions about competitive effects instead of looking at, a paper trail of evidence. But you have the new merger guidelines. And so the new merger guidelines that tell you what the agencies do for these cases, for those who aren't familiar, the new merger guidelines, the conventional wisdom within the antitrust world is make it easier for plaintiffs to win than they used to do, for a lot of reasons. So my first question is, do you have a prediction about whether the court's going to take a merger case? And the second one is really similar, which is Congress is now, so one of the things that's different in the last 30 years is Congress is much more involved in antitrust than they used to be, right? So we've got, in addition to, maybe we get a Twombly repeal, or maybe we don't. I understand there's implications outside of antitrust, which I'll learn about tomorrow. But there's the reverse payment statute, there's RPM legislation to do away with Legion, right? So you've got this whole flurry of activity that's not really been present in that sort of systematic force for 30 years also. And most of it is to make cases easier to win for plaintiffs. From an error cost perspective, this means higher error costs. And the era in which we got all these error cost decisions, work group and the like, were when it was free lunch for plaintiffs in antitrust cases without having to prove competitive harm. And so my initial thought is most of this stuff that Congress is doing and what the agencies are doing is going to see a backlash in the Supreme Court, being more forceful about safe harbors, being more forceful about lining up rule of reason doctrine to get per se legality in some instances, and so may go the opposite of the intended effect. But I may be by myself in thinking that, so I ask for your predictions outside of the paper. I understand, but because I'd like to hear it.
Excellent. Well, thanks for the comment, the empirical evidence comment, and I 100% agree, and I will be talking to you, trying to get some sites. The reason that I emphasized empirical evidence in Legion and not in the other cases is because I'm trying to, that was the part of the paper where I was trying to show what the court's doing, and it is the only one of the cases where the court really emphasizes empirical evidence. The reason I emphasize Ippolito and Overstreet can be the same, is exclusively is because those are the ones that the court mentioned. So, but that's an excellent point. It'll strengthen the paper to put in to show that not only is the court, not only what the court is doing, but the court's doing the right thing. It fits with the empirical evidence. In terms of the merger law question, you asked, make a prediction, is the court going to take a merger case? How could it? I mean, this is the problem with merger law. I mean, we have terrible Supreme Court decisions, merger decisions. They're terrible. Everyone thinks they're a huge joke. Brown shoe is, you know, everybody laughs at. But it hasn't ever been overturned, and the reason is it's really hard to get a merger before the Supreme Court. If the government wins in a merger challenge, then the parties to the merger agreement can't sustain that agreement indefinitely. I mean, these are fragile agreements. Once you lose in a circuit court of appeals, well, you might as well just call it a day, right? So they're not in a position to appeal to the Supreme Court. They don't have standing or whatever. When the government appeals, the parties, or when the government loses, the parties merge, and it's so difficult to craft a remedy post-merger that the government doesn't usually appeal. So now they did in Whole Foods, and I had really hoped that would go to the Supreme Court, because I think the DC Circuit decision is just ridiculous. But I just don't know how you could tee it up. The good news is that everybody knows that the old Supreme Court cases that have never been overruled are not good, and no one pays any attention to them. I mean, the government just, the merger guidelines look nothing like a brown shoe. The old ones don't, the new ones maybe look a little more like a brown shoe, but not that much. So I don't know what the court could do. Do you have a thought on that?
I mostly agree, right? So, I mean, Whole Foods was the only thing that came close, and, you know, some shenanigans with the DC Circuit aside, we probably would have got Supreme Court review. And for the same reason, it's also the cost of the parties. I mean, that one's it's much harder to tee up. And part of why I think it's more likely is because my view of the new guidelines is that they're maybe a little more closer to brown shoe than you think they are. You know, and so I see more cases getting litigated. Mm-hmm. And somebody saying, you know, I'll win, right? Because the guidelines are a significant departure even from what was going on in
Right. Well, it would be a great thing. I mean, we have some really unfortunate precedents on the books. It's an area where the court really needs to clean things up. It hasn't had the opportunity to. So, let me respond to Josh's last point. What happens if Congress gets more involved? Well, I don't think it will. Maybe a Twombly repealer, I don't know. Brian can talk more about that. But I think on the antitrust questions, the only thing that immediately pops to mind for me is statutorily overturning Ligon. And I don't think that's going to happen. I think that Congress, you know, for all its talk, realizes that the court actually is doing a pretty decent job in a really difficult area, and we're unlikely to get a better result if Congress intervenes. If it does, then I think you're exactly right, Josh, that the court will find other safety valves. This is an argument that Josh makes in his American Needle paper, basically saying that Twombly, which ratchets up the pleading requirement, allowed for American Needle, basically because we now have Twombly as a screen. We don't need the intra-enterprise immunity doctrine as much as we did in the past. But if Twombly is repealed, then the court can come up with all sorts of different screens that make it hard to bring private lawsuits, and I think that's exactly what you'll see if Congress does muck around. If Congress comes in and overrides the Ligon decision and says that RPM is now going to be per se illegal, then we'll see exactly what we saw when the court decisions declared RPM to be per se illegal, which is that the court created all of these loopholes, making it extremely difficult to show an agreement among manufacturers and their retailers concerning resale prices. So the court's in a very good position to create safety valves all over the system if Congress does something that it deems to be inconsistent with consumer welfare.
Brad?
And this might be repeating a little bit of Josh's comment, and I apologize, but I'm not sure I fully understood all of the comments, so that's my mistake. I'm wondering to what degree you think that the court is consciously motivated by this approach. Because it strikes me that some of these questions, at least in some contexts, maybe some contexts are pretty straightforward, but in some contexts, it's an awfully complicated empirical inquiry itself to determine what the costs are and then to balance them against one another. And so there are some limits about it as potentially as a prescriptive theory for what courts should do due to their institutional limitations. A second kind of comment / question that I would be interested in your response to, which I think, again, is sort of dovetails with what Josh said, is I'm wondering now, after reading your paper, to what degree antitrust even fits at all within the pro-business meme of the Roberts Court. That is, it's one thing when we have areas like, what Jonathan writes about, environmental regulation, where you could say there's a trade-off between environmental degradation and growth of business, or consumer protection. But here, everyone seems to agree that the goal is to enhance consumer welfare at the end of the day. Now, the court might not do that. It might mess up, but there's no pro-business side. Everyone is sort of, there are businesses, right, that are involved, but the end goal is pro-consumer from everyone's perspective. And so I'm wondering if it just is fundamentally different in some way, more like, say, patent questions, in the sense that it just doesn't really fit within this pro-business, anti-business paradigm that seems to be being built up about the Roberts Court.
Thanks. With respect to your first question about are the justices consciously doing this, I think some are. I certainly think Breyer is. Breyer, when Breyer was on the appeals court, he wrote, several decisions where he, basically lays out this kind of decision theory model. He says we have to, antitrust is not economics, and when we try to catch every anti-competitive instance of business behavior, we inevitably chill things that are close to that but pro-competitive, and so we have to be really careful about this chilling effect, and the rules have to be administrable so that you can explain them to your client. He talked a lot as a circuit court judge about those things, and in the Credit Suisse opinion, it's very interesting. His discussion of sort of the costs of antitrust in the Credit Suisse decision comes in the part of the analysis where he is trying to decide if there's a conflict between antitrust and the securities laws. Well, it seems to me that what you do, if you were actually trying to find out if there's a conflict, is look at the regulations, look at what antitrust decisions say, and see if they conflict. But that's not what he did. He said, what are the costs of antitrust adjudication here, and is it worth it? And so Breyer, I think, has explicitly adopted this sort of decision theoretic approach. I think probably other members of the court, I think, have also, if pressed, would say the same thing. Scalia, I believe, with his regulatory background, thinks in these terms. Perhaps his former clerks could clue us in on that, and the former Thomas clerk in the room could clue us in on what Justice Thomas thinks. You know, the author of, the person who most explicitly spelled this notion out is Judge Easterbrook. They're all aware of this work. They're all aware of this notion. And, you know, at the very end of my paper, I quote from one of Stephen's dissents, where he basically rails against this notion. I mean, that to me was quite telling, that there must have been some discussion amongst the judges about how important this kind of concern about error costs, et cetera, is. Stevens doesn't like it, and he's protesting. So I think they're consciously doing it. With respect to the second question, I'm so happy that you said what you said, because that's actually one of my central points, that this meme is stupid when it comes to this particular area. First of all, as Josh pointed out, and I think I dropped this in a footnote somewhere in this ridiculously long paper, the plaintiffs in these cases are businesses. So you've got a business against a business. How can you say that when the defendant wins, it's pro-business? Because if the plaintiff won, a business would have won. I mean, I think, you know, the idea is that if it's pro-regulatory, then it is pro-consumer. And if it leads to the regulation condemning less conduct, it's pro-business. I think that's what people like Erwin Chemerinsky, who characterize these as pro-business decisions, really mean. And I think that's wrong, because you know, when we say that you are not allowed to engage in this particular conduct because it violates the antitrust laws, if we say that too much, we're going to chill things that really are good for consumers. And a great example of this is Intel, I think. Intel got in trouble for loyalty rebates. It got in trouble for cutting prices. Just, you know, it's ended up, this didn't get litigated. The case was settled. I mean, it got litigated, but it didn't get, there's no opinion, but the case was settled. But ultimately, at the end of the day, because of this lawsuit, which, if you take the view pro-regulation is pro-consumer, you know, a finding of no violation is anti-consumer. If you take that view, this was a pro-consumer decision. But what it did was, you know, penalize Intel for giving rebates that resulted in above-cost prices. They weren't predatory prices. They were just aggressive price cuts. And so, you know, that's the thing about antitrust. If you take it too far, consumers are going to get hurt. If you don't take it far enough, consumers are going to get hurt. The trick is to find the sweet spot, and I really think that's what the court is trying to do in these decisions.
Let me push against that a tiny bit. And since one way to think about the court as pro-business meme is to say it's not pro-business, anti-business in terms of litigants, but it might be a hostility to, and this came out a little bit in the discussion of Adam's paper, hostility to the use of private litigation as a regulatory mechanism. And so cases like Stonebridge can be explained in part, perhaps, by, if one adopts this theory, as, well, we don't like judicially created private causes of action more than we've already established in our precedents. If Congress wants to do it, Congress can do it, and we're not doing anything about the SEC. So if the government thinks there's a problem here, it can still come in. All of these antitrust cases are private cases, and they're all, I think, except for Twombly, right? They're all private cases, and they're all competitors, I think, except for Twombly. And it seems that a court could not necessarily be pro-business in a simplistic way, but hostile to the idea that private regulation, and in particular litigation by competitors, using the judiciary as opposed to relying upon experts in the executive branch as some sort of intermediary, is an effective way of advancing the goals of the statute. And whether empirically we could ask whether or not, say, private litigation is any worse than, say, overly aggressive FTC prosecution, and perhaps we'll have empirical evidence of that relatively soon. to figure that out. But I mean, what would you think about that alternative hypothesis, that it's not that it's pro-business, but it's hostility to plaintiff-driven regulation of business conduct?
I certainly think that's part of the story. I mean, a key difference between the antitrust context and the securities context is of course, that the private right of action under Rule 10b-5 is judicially created, and the private right of action in the antitrust laws is right there in the statute. In fact, it's really broad in the statute. Any person who shall be entered in this business or property. So the court, I mean, to the extent I think Adams was making the point, it makes perfect sense to me that the court, since the court has created this right of action, it's reluctant to make it too big. Well, here it didn't create the right of action. Congress did. But it is certainly worried about too much private enforcement. But I think that just raises the question, well, why does it care? Well, yeah, it cares to some degree because you don't want these cases clogging up the court system, and you don't want basically strike suits that that force people to settle non-meritorious claims to avoid extensive e-discovery and all that stuff. And you see that in Twombly. I mean, the court is very explicit that that's part of its concern. But, I mean, the bigger issue is that these private lawsuits hurt consumers. When LePage is decided by the Third Circuit, and the Third Circuit enters a $68 million verdict against 3M for discounting packages of consumer products and gives no standards whatsoever for knowing when you can and can't do that. There's no sort of price-cost comparison where you have a safe harbor. Well, I mean, the business community's up in arms. They don't, if they have, package discounts planned for various retailers, they've got, lawyers scouring to see if they might run into treble damages liability if they adopt those things. And so I think you're exactly right, Jonathan. The court is concerned about private enforcement, but the excessive private enforcement, but the real driver is that the private enforcement is going to have a chilling effect on pro-competitive business practices.
And so then as a quick follow-on, you would not predict the court to be any less aggressive in applying this framework if it's the FTC bringing the case, or the Justice Department as opposed to private plaintiff? Because that is one way I think you would test the hypothesis.
Yeah, absolutely.
Is if the court got an FTC-driven case.
Yeah. I mean, this is a point that Dan Crane, I think, has made, that when the government is a party to the suit, then the court should be more deferential. Yeah, I would probably expect the court to be more deferential, but
Yep.
see what Josh has to
Well,
say.
really quick on this point.
Yeah, it's on this point. I'll wait if he's on this point.
Go ahead.
It's the same point. I haven't read Judge Easterbrook's article, on which you relied rightly, I think, for a while, but I believe one of his points was precisely, you ought to be very, very suspicious of private competitor lawsuits in a way
sure.
you shouldn't be, right? So
Right.
it fits your model, right? And then if they come out differently in an FTC or whatever case, I mean, some other antitrust case where the government stands behind it, it's not a rejection of your theory at all if they come out differently. Seems to me that's the straightforward answer. I mean, that's just, it comes with the model.
Right.
You just cannot distinguish between his hypothesis and yours until you see an actual government case.
On this point, Josh?
But on this point, I'll wait.
Or Alan, go ahead.
But it's the same statute. And if the government goes and wins one case, then when the competitor comes in the next time and says, well, if the government says it's illegal in that case, in my case it's the same, yes, it's true that, that some of these things are not applicable, but the law is the law, and I don't see how they can come up with a different result.
Josh?
Okay, so the answer is that they don't. It's the same law. But when Tom says that what the court's done is in response to private rights of action, the response has been consistent with the error cost framework. What they've done is they've said, oh, you can have your private right of action, but you must prove, since we know that most of this behavior is pro-competitive, and only a little bit of it's anti-competitive, and there's high error cost rates, you got to prove this is one of the bad times. you need to prove consumer well. If you can do that, you can win your case. And they say, FTC, if you can do the same thing, you can win your case. What the FTC's argued recently is that when they're in a suit, they ought to have lower burdens. And so this is actually sort of more of an issue than this discussion really hints at. The FTC has said, well, when we bring the case, by the way, we've also got this other statute, Section 5, and by the way, we'll tell you what it means when we get to court. Right? We don't have to prove the same sort of consumer harm because where the experts trust us. Now, what's happened in real cases is the DC Circuit, you take like the Rambus litigation, for example, and probably what the DC Circuit would have done to Intel, is applied a Sherman Act-like standard to Section 5 and sent the FTC packing. That's what's happened. Every time the FTC has tried to say all of those error cost considerations that don't apply to that apply to private people don't apply to us, they've lost. But I think we're headed towards another one of those fights.
Brian? You're on both the short point and you're next, and you're next anyway,
Okay,
so
good.
you get to unify the.
A quick question
threads.
then on this discussion of whether the government is treated differently. Isn't the government filing amicus briefs in at least some of these cases? I remember one of the cases I litigated was Volvo, and I think they intervened, or they filed an amicus brief in that case. Are they filing amicus briefs in these other cases?
Yeah, they are, and largely on the defendant's side. I mean, in the Ligon case, both agencies were pro-defendant. There was one case where they split. What was
They split in
Credit Suisse.
They split in Credit Suisse. They split on the petition for cert and the reverse payment cases.
Right.
And more recently, the FTC. I don't think the FTC joined the DOJ position in American Needle.
Right.
Okay.
So yeah, they're weighing in.
So it's hard to tease out what the effect of that is. I guess they're split in some of these cases.
Well, and it was really complicated in the Bush administration because the DOJ and the FTC really had different views about the limits of antitrust. Frankly, the Department of Justice really bought into the model. Essentially, the agencies together held a year-long or more than a year-long series of hearings on various business practices and produced this very elaborate report that the FTC then didn't join. And when Christine Varney took over, when Obama took over and Christine Varney came in as head of the antitrust division, one of the very first things she did was abrogate that. So we did really have a conflict between the FTC and the DOJ. But they're weighing in. Everybody's weighing in.
I'm just curious if you use the amicus briefs to kind of tease out whether the government was getting more or less deference than private litigants would. And before I get to my question, I just want to associate myself with what Jonathan said. And that is, I think if you see the political divide in business versus consumer, I think what Brad said makes a lot of sense. It's hard to fit the antitrust into that kind of scheme. But if you see the political divide here as business versus plaintiffs' lawyers, I think the cases can perhaps be fit into that scheme. And the highfalutin way to say that is they're worried about private regulation. But the more crass way to put it is just Republicans don't like trial lawyers; they like businesses better. And so I think you might be able to fit it into that scheme if you can't in the business versus consumer scheme.
I don't disagree with that at all. All I'm saying is, I don't know what the justices think of plaintiffs' lawyers as a class. You former clerks can. Yeah, I have my guesses. But I know that a real concern with the work of plaintiffs' lawyers in this area, even if you love plaintiffs' lawyers, even if they just adored them and think they generally do the Lord's work, in this particular area, they can do really bad things because if there's an antitrust, it's not like securities where if you find a fraudulent statement in some company's document or whatever, that case is decided and the company, it's bad for that particular company, whatever. There are precedents involved in that as well, but in antitrust, when the court's condemning a novel business practice, it condemns it throughout the entire economy. And there's no way to fix that unless you get a statutory override, which is highly unlikely, or another court decision. So, I think one of the reasons they seem to be so hostile to plaintiffs' lawyers isn't any sort of antipathy toward the plaintiffs' lawyers, although that might be there, but it's really because their work can have such an anti-consumer chilling effect in this particular area.
Let me ask a quick question, and that is, I had a question about the metric that you used, this minimization of the sum of the decision costs and error costs. My first question is, so the way you define decision costs is basically how hard it is for the court to apply the test, plus how expensive it is for the parties to litigate the test.
Yeah, and I guess I wasn't real precise on that. I think you should also factor in the cost to business planners of uncertainty, but of just deciding the outcome.
Right. So okay, fair enough. Because I was going to say, if we stuck with what I thought you defined it as, it seemed to me the decision costs are going to be routinely dwarfed by the error costs. How expensive is it for the court to sit through some briefs and expert reports going to be dwarfed by messing up who's liable and who's not. And so much so, I would almost throw it out of the equation altogether.
Well, some people have done that.
But if we
including my friend Josh. When a lot of people use, rather than talk about decision theoretic analysis, they'll just say error cost analysis. It all comes down to the error cost.
Okay.
I will absolutely agree that that's the biggest part of the calculus. But you can imagine that we could come up with some liability rules that were really terrific at getting the right answer. Fantastic at getting the right answer. We'd come up with, I talk about Posner's proposal for regulating oligopolistic pricing. He tried to do this. He says if you can police oligopoly in the absence of an agreement by looking at the following 17 factors to decide if this particular element is met, and 14 other factors to decide if this particular element is met, and probably we would have fewer false negative. I bet we could reduce, if we really could do what he says, we could reduce error costs. But it would be ridiculously expensive to administer that system. So I agree with you that error costs are the bigger part of the calculation here. But I like to keep the decision costs in there just to remind people that's one of the things you have to keep in mind when you're formulating a rule.
Right. And I would especially, just to finish up, I would especially keep them in there if that's where you're putting the uncertainty cost to business. Because the one thing that I couldn't figure out where it was counted is if a business doesn't know whether they're going to be found liable or not, that obviously affects their behavior in a costly way. And so when you look at error costs, you say, what's the probability of getting it wrong, and then what bad things happen when we're wrong. But there's also, what's the probability of getting it wrong, but what bad things have happened in the meantime, even when we get it right. A business could be found not liable, but because they weren't sure for so long, that has implications. And so I wasn't sure where that fit into the calculus.
Honestly, I'm not 100% sure either, because I can think of how that would fit into error costs.
Okay.
If you're doing the math, you discount to account for risk. But I got to.
But even when the answer is right, the uncertainty in the meantime is costly.
But the uncertainty in the meantime comes because the rule's unclear before. Right. So then it's an error cost.
That's an error cost.
The answer is it's an error cost. Right. It's not cost of administration.
There may not be an error. Right. So the court could apply the rule correctly, but because it's unclear.
So it's not an error cost. If a decision happens in 2010, the social loss before they clean up the rule is not an error cost of the decision 2010.
Right.
It might be an error cost of what the rule was. Right. So if you're doing an error cut, right? So you're talking about it's marginal, not averages, right? So does the decision in 2010 improve on the margin? What's the marginal error to effect on type 1 errors, type 2 errors, and administrative costs? Guys like me ignore administrative costs not because it's technically right, but as a simplifying assumption because we think the error costs are really big. We think we get even close to getting that right, we do better than now.
Mike?
Yeah, it just sort of one brief footnote. Somebody ought to sort of take this discussion about pro-defendant doesn't mean pro-business, because as a political scientist, I can assure you, the standard Michigan database that everyone uses, Smith and Siegel codes, defendant wins as pro-business and anti-consumer. So political scientists from here to eternity will burble about the business-friendly, Roberts Court, no matter what you lawyers say. That was my point, however. I just have two questions. One, and both are sort of about the dogs that didn't bark here. One is they're very, very interested in, apparently, substantive antitrust rules, but not so much in the kinds of things that animate them in securities law. Who can sue, right? Immunities, that sort of thing. I mean, jurisdictional or proto and pseudo-jurisdictional things. I would start that list with Parker versus Brown and its progeny. There's nothing on that. You can add the Illinois brick problems to that. If you want to, you can sort of wait one more, which I would prefer. Take one more run at Summit Health and its idiocies. But there are a lot of those kinds of non-substantive but sort of quasi-jurisdictional. I've seen nothing in that vein, and I wondered whether there's some sort of either some explanation that fits your model, or something out there in the litigation economy that explains the preoccupation with substantive antitrust law questions as opposed to the other. That's one question. And the second question I have is, I'm very glad these two papers, the securities and the antitrust paper, are next to each other. And if I were you, I would keep it that way in the book, because it's just such a dramatic contrast, right? Two sort of fairly related fields, I mean, in some ways. And you think you're confronted with a very, very different court, right? They're just making up substantive rules of decision as they go along. And they do that with an unbelievable confidence in antitrust. And you can say, well, I mean, and Adam suggested this, in securities law, they think Congress will always come back. And so it's this ongoing dialogue, and that's not really true in antitrust, because after the Sherman Act, nobody ever did anything, except it's not true, right? There's this little, the Volvo case in that context is a little bit more interested, because basically what they did is they emasculated, as far as I can tell, emasculated the entire Robinson-Patman Act. Now, I yield to no one in my endorsement of underhanded judicial maneuvers to get rid of stupid statutes. But you could have said, as two justices did, maybe Congress should say something about this, right? And the much bigger elephant that sits out there is legal, right? Where it's not the case that Congress had no opinion about this, had never said anything about it. Justice Breyer has that long disquisition about, wait a minute, this is different, Congress has paid attention, it's, if anything, done the opposite. There may be an answer to that, but, I mean, Justice Kennedy's answer, so far as I can tell, is we don't care, because this is our field, right? And they do this with utter confidence. And the only other contrast in the sort of Roberts Court's universe that I can think of is exactly, or is almost exactly like that, which is also sort of this sharp discontinuity, is maritime law versus ordinary tort law, right? If it's maritime law, if it's Exxon, if it's on water and it floats and it has propellers, our rules, guys, for whatever reason, right? Because otherwise you're in this sort of eerie wonderland where anything can happen, right? And it's the discontinuity that to me is sort of the most striking thing about the sort of juxtaposition of these two papers. So those are my two questions.
Well, with respect to the first question about why not more focus on procedure, we do have, I mean, of these 8 cases, I didn't talk about the Volvo case because Robinson-Patman is not a consumer welfare focused statute, and it doesn't fit well with this model. But of these cases, 2 of them, I mean, I think 3 of them really are they're not substantive. I mean, American Needle, I guess, it sort of is, but Twombly is a procedure case, and it has substantive implications, I think, for antitrust. It basically says that sort of oligopolistic coordination is not an agreement, which is a huge point that people have been debating, and it's sort of slid in, I think, in the Twombly case. But it is, it is a procedure case, and it's a huge one, right? It's the most cited case. Brian left, but I think his paper says something about it. It's either the most cited Supreme Court decision or it's on track to be quickly. I don't think that they're scared of procedure. It's just that it hasn't come up yet. A lot of the hard work has been done. The Section 4 of the Clayton Act creates this very broad private right of action, but it's been cut back by the antitrust injury requirement, antitrust standing requirement, indirect purchaser rule, various things. So I think when the court has the opportunity to consider another one of these things, it'll take it on. In terms of the contrast between securities and antitrust, in terms of the court's engagement with the substance, that is really striking. Adam's making the point that they're not interested in securities law. They're interested in statutory construction. Well, they're really interested in antitrust. They are, which is awesome. But part of that is the nature of how we've written our antitrust laws, and that's what I start the paper with. It's hard to write antitrust rules where we spell out ex ante what you can and can't do. And we didn't do that. We instead posited standards. No unreasonable restraints of trade, no unreasonably exclusionary conduct, which means that the conduct has to be evaluated after the fact. And from pretty much the very beginning, the court has taken the antitrust laws as sort of an implicit delegation from Congress to craft a common law of competition. That's how they're interpreted. Is that a good thing or a bad thing? I actually think it's a good thing, because I think Congress would really, really, really mess it up. I think they really would. When Congress has stepped in and tried to, pass detailed rules on particular business behaviors, that have to do with antitrust, it's usually done a bad job. Robinson-Tapman's awful. The specific tying provision of the Clayton Act, Section 3, is bad. The court's kind of interpreted it away. But the court, I think, has generally done a better job than Congress, and I'm pretty happy that it has viewed this as a delegation from Congress to craft the common law of competition. With respect to the Legion case itself, you make the point that Congress did say something about Dr. Miles, which is the old case that declared resale price maintenance to be per se illegal. I'm assuming that you're talking about the repeal of the fair trade laws. For the uninitiated, Dr. Miles said that minimum RPM is illegal automatically. That basically means that if a manufacturer dictates the retail price of his products, it's an automatic violation. And then Congress passed a statute that allowed states to adopt these fair trade laws that if a state wanted to, it could opt out of Dr. Miles. And in fact, a state could adopt a law that made resale price maintenance per se legal. And so a lot of states did that, and I think it was 1975, sometime around there. Congress repealed fair trade. Right? So Breyer, in his dissent, takes the position that in repealing fair trade, Congress was basically approving of Dr. Miles. But that's not what a repeal of fair trade did. Fair trade said resale price maintenance is per se legal. You can do it willy-nilly, you can never be in trouble for it. In repealing fair trade, we basically say, okay, we're going to let this be subject to antitrust scrutiny. The antitrust rule in place at the time was Dr. Miles, but Congress didn't indicate that was, it had to stay there. So I don't think that Congress has really weighed in and put its imprimatur on the rule of Dr. Miles. don't know.
I have a bunch of folks. We have about 12 minutes. I have David, Alan, and Adam on the list, and Matt. So, David.
So, 3 points. The first one is, if there seems to be an emerging consensus in this room that the Roberts Court is hostile to private rights of action as a method of enforcing sort of public goals or ends. I think that's interesting because it's not necessarily the case that the conservative court, it's not obvious to me that the conservative court would necessarily choose that sort of hostility. Richard Epstein's a big fan of the common law over regulatory approaches. Ron Gilson has even suggested the same thing. And it could be that, of course, the Roberts Court is just against regulation of private enterprise and activity, and that they're more worried now. They're expressing a mood that suggests that the kind of regulation that they should worry about most is private rights of action, as opposed to regulatory enforcement. So that, they'll keep Chevron, they'll try to restrict, class actions and that sort of thing. But it's not obvious to me that they would always feel that way, or that would be a sort of consistent method of jurisprudence or whatever. Okay, so the second thing is, and this I guess built on what other people have been saying, is I think that I like I think it's a thoughtful take on these antitrust cases to look at decision theory. But I come back to sort of Occam's razor, and I wonder if it's not worth engaging, maybe even seeing those words when you talk about, it seems to me that with the exception of American Needle, the plaintiff always loses in these cases. We don't know. You've got a great example, and that you've got a great justice, and that Justice Breyer talks about the cost of error and in the Credit Suisse case. But we don't know in these cases, in the other cases, whether they're really worried so much about error, or if they just want to, stop people from suing businesses for antitrust reasons. And it seems to me that they want to stop people from suing businesses for antitrust reasons is a simpler explanation than one which talks or thinks about error costs, even if Frank Easterbrook did so. And so it seems to me that may be just masking a really more straightforward explanation. And I have an alternative explanation, which is, I don't have a strong theory of antitrust or anything, but I think that, it's operated largely as a default, where there's no other regulation out there since 1890 of business. There is antitrust enforced through sort of common law means. And I wonder if what's going on with the Roberts Court isn't sort of a Justice Powell-like, to use Adam Pritchard's sort of approach, but maybe less effective than Justice Powell, sort of effort to break what I think is currently arguably an explosion of antitrust liability. As companies globalize, China now has an antitrust law which they copied from Europe. Europe has its own aggressive and vigorous antitrust enforcement, which some people say, like the Champions League is one of the reasons it's a unified state. Got the Euro, the Champions League, antitrust. But anyway, there's this story that increasingly there's global antitrust, and in the United States, the stuff that's happening in antitrust that seems to me to be hot doesn't seem to be something that the courts have much sort of purchase over. So you've got CFIUS reviews now, which is sort of the new sort of government regulation of mergers, which has lots of private bars in DC and New York worried. And then you've got the FCC increasingly getting involved in if Google is the next big sort of antitrust case, then that's going to be something that isn't really going to involve private rights of action in the Supreme Court. And then you've got the financial crisis and the Federal Reserve, which increasingly has these, is reimposed through Dodd-Frank and will continue to do so through legislation, these strict controls on the abilities of, financial conglomerates to expand beyond a certain size in the economy. And so all of this has not much to do with what the Roberts Court is doing in antitrust. And so I sort of wonder if, what we've got here is this sort of Justice Powell-style break in sort of administrative regime, which, if you look at it broadly, is really a story about the growth of antitrust antitrust regulation?
Well, so I think you just applied two versions of Occam's razor to my theory, and the first one was that the simplest explanation is plaintiff always wins, or sorry, defendant always wins, except for American Needle. And the second one is that antitrust is a residual regulator, and we don't need antitrust. We need it less U.S. antitrust laws as we had more other regulation that is addressing the same stuff.
Right.
Yeah, so I'm not, I guess, I'm all for Occam's razor. I don't think that in this case it really explains the cases nearly as well, either of those theories. Take the first one, the first theory that the defendant always loses. Well, the court in these cases, it's not as though all the court does is says who wins, plaintiff wins or defendant wins. The court, posits a liability rule. And so you have to kind of look at the content of the rule and see what you can infer from that. So take the Ligon case, for instance. The members of the Chicago School, including Judge Posner back in the day, said that resale price maintenance should be per se legal. No challenge whatsoever to minimum resale price maintenance. That's not what the court did. The court here said, no, we're going to subject it to the rule of reason. These are the economic factors that one should look at in deciding whether an instance of resale price maintenance is pro or anti-competitive. I don't think it would have done that had it just been sort of trying to get rid of these cases, or if it really were that pro-defendant. I mean, all of the substantive cases, Weyerhaeuser, Linkline, the court says way more than just who wins or loses. It posits a rule, and if you look at the content of the rule seems to take account of the state of the empirical evidence on whether the practice is pro or anti-competitive, the theories of pro-competitive benefit and anti-competitive harm, and whether the prerequisites for those various effects exist or not, and then craft a rule that's reflective of the theory and the evidence. If the theory and the evidence suggests that most of the time the practice is pro-competitive, then it ought to be hard for the plaintiff to establish liability. But in all of the cases, the court allows for the plaintiff to establish liability if it jumps through the proper hoops. So, I don't know, I think that the first razor is just, it cuts too, I don't know what the analogy would be. It's too simple. With respect to the second one, antitrust is is the residual regulator, and since we've had this explosion of other regulatory bodies, we don't need domestic antitrust so much. I'm not so persuaded by that one either. Certainly, some of these cases, like the Credit Suisse case, and specifically, I mean, that is definitely what's going on in Credit Suisse. We don't need antitrust here because we've already got a cop on the beat, the SEC. So sure, Credit Suisse can be explained in those terms. But with respect to the other ones, I mean, the practice at issue in most of these, maybe not Linkline, but most of these isn't really regulated domestically by any other entity. I mean, resale price maintenance, if you've got a domestic instance of resale price maintenance, the European antitrust law isn't going to reach that. There's no regulatory body that is regulating in that area. So I think that the notion of antitrust as residual regulator and let's limit it to the areas where we need it is persuasive, but I don't think it explains these cases other than the Credit Suisse case.
Where we have about 3 minutes left and I have 3 people on the queue. So Alan, Adam, and Matt, if you can pose questions or comments relatively quickly, and then Tom might have a chance to respond. Otherwise, he'll have to tell us over drinks and dinner.
The divide is not between consumers and business, but between little business and big business. And I think this court, these plaintiffs are all little businesses, consumers. They're kind of like, as I thought it was before Mike said it, kind of like the plaintiffs in the Robinson-Patman Act cases. Indeed, some of the allegations here are first cousins of the kind of things you would allege in a Robinson-Patman Act case, but they don't fall within the literal terms of it. And to the extent economic analysis has anything to do with it, obviously the Robinson-Patman Act is not an economic freedom, it's a protection of small businesses. And so I think this court thinks that big businesses are good, we need them, and that it presumes that they're acting in good faith because they find it in lots of other contexts. And while I don't think that explains it all, I think it's a little bit different take on it than the plaintiff always loses.
Adam?
I'm interested in the lack of a differential between public and private enforcement. Maybe it's the path of the cases that are coming. But I also wonder whether there's a difference in the court's belief in the core of the regime, right? So the core of the securities regime is we need to stamp out fraud, right? Fraud is bad, no one disagrees with that, and we think government enforcement is actually quite important for that. In antitrust, I see the core of the prohibition as, you know, these guys are sitting in the back room with cigars and they're fixing prices, right? And if we thought that the government was busy going after that sort of conduct, we'd make sure that there was a lot of room for the government to do that. But is that what the government does, or is the FTC off coming up with creative theories that look a lot like what the plaintiffs' lawyers come up with, because that's the raison d'etre of the FTC, is to come up with novel theories of why things are anti-competitive, because they can't go find people in back rooms fixing prices, right? If they could keep busy doing that, that would be fine, but that's not what they do.
Well, I mean, I think they do, you know, go after cartels on occasion. And when they do, it's uncontroversial. Cartels are bad.
Yeah.
But you're right, that they do, you know, one point that I think you make that's really fantastic is we could analogize the market failure or not the market failure, but the harm in a securities context and the harm in an antitrust context as kind of the difference between an intentional tort and negligence, or some kind of carelessness. We don't worry about over-deterring fraud, right?
Right.
There's no, I mean, we don't worry about that. We do worry about over-deterring risk-taking, you know, so we don't allow punitive damages for negligence, and we do allow punitive damages for intentional torts, that sort of thing. I mean, antitrust, the harm in antitrust looks a lot more like carelessness than it does, you know, an intentional tort, a fraud. And so I think it makes tons of sense for the courts to be less willing to intervene because of a concern about chilling good stuff in the antitrust context than it is in the securities context. And I think you're right that the government agencies, maybe it's because it's hard for them to police cartels, push the envelope. And we certainly, I mean, I think we certainly saw that with Intel. I think we saw it in the Whole Foods case with the FTC going after the merger of Whole Foods and Wild Oats. I mean, these aren't clear cut for sure. And I mean, and in my opinion, in both of those cases, the FTC went after something that was pro-competitive. I don't know why.
Matt, we're out of time, but we'll give you an extra minute tomorrow morning. But thank you, Tom. The shuttle bus is